Good evening, everybody. I'm Andy Bunn, Executive Director of the Hawaii Conference Foundation. And our presenter this evening, I've had the great pleasure of working with for many, many years. I'd like to introduce Kimi Ide-Foster, who is a Senior Associate at the Chun Kerr LLP law firm, which is my old law firm, and is celebrating its 50th year of service to the community this year. Kimi practices in the area of real property and finance and business transactions and organizations. Primarily transactional work, and she has also lots of experience working with nonprofit organizations, including churches of all varieties, UCC churches and those of other denominations as well. Kimi received her Bachelor of Arts from Pitzer College and her Juris Doctor from the William S. Richardson School of Law. While in law school, Kimi was the editor of the Asian Pacific Law and Policy Journal, was a member of the Space Law Moot Court team. That sounds like a lot of fun to me, frankly, and did important work participating in the Hawaii Innocence Project. Professionally, she's been active with the Bar Association and has been a board member with the Hawaii Young Lawyers Division. She's a board member for the William S. Richardson School of Law Alumni Association, and she is the current president of Hawaii Women Lawyers. Her community activities extend to coaching for the Special Olympics Hawaii. Kimi is a talented swimmer. She is a member of the Iolani Alumni Association and the EO Society. She has participated in the University of Hawaii Law School Alumni Bruisers football team. That's a women's alumni football team. So watch out for Kimi. And she has received recognition from the Hawaii State Bar Association's Leadership Institute, and most recently in Pacific Business News as Women Who Mean Business for 2020. So it's a great pleasure to have Kimi here with us this evening, and I thank you, Kimi, for joining us, and hope you could shed some light on some of these important legal issues for our churches.
Thanks, Andy. That was a very nice introduction. I guess it has been many years at this point. Doesn't feel like it, but we can get started on time. So the way this is going to work is I'm going to walk you guys through a PowerPoint presentation. Some of you might have attended the one that I did, I think, was it earlier this year, Andy? Honestly, COVID just kind of screwed with my sense of time here. And I think that your questions, like Lori said, will be funneled through the question answer. Where I think it's appropriate or where I think it'll be helpful, I will also bother Andrew to kind of chime in. But on the whole, this will be like a very general overview topical seminar on renting and leasing your church's property. So without further ado, if it's okay with you guys, I'm going to go ahead and get started. Okay. Are we good with the PowerPoint? Okay. So, like I said, this is a seminar about renting your church's property. Principles, practicalities, and precautionary tales. I love me some alliteration when I can help it. Like Andy says, I'm an attorney with Chun Kerr, and I do focus primarily on real estate. So these are things that we touch pretty much every day. We see them from the really big sizes, so think of hotel leases, shopping center leases, all the way down to market stalls and leasing and licensing small rooms in churches areas. So, okay. First thing is you've probably heard people say things about what's on title. And the very first thing you're going to want to do when you have any kind of property is you're going to want to get a title search. A title search is kind of like a snapshot in time of what's on title at the time. There are professional companies that do this. We often use a company called Title Guarantee, but there's a whole variety of people that do title searches. And basically what they do is they search the title of the land, so they track the ownership of the land, and everything that's been recorded against it and is still on title, all the way from the Great Mahele, so many, many, many generations ago, to the date that you're asking your search for. You can run a title search on the fee interest, You can run on the leasehold interest, you can run the sublessee interest, and so on and so on. Basically, the front page is going to look a lot like this. You've got your title holder, their interest, and then people that you can contact. And so when I say something like, what's on title, the reason that we're asking is we want to know who has rights in the property besides you. You as the fee owner or you as the lessee, we understand that. But we want to see what else is there. We want to see if there's any easements there. We want to see if there are any recorded leases on it. All of that is important just because it gives you a sense of, one, you should know what's on your property. I know that when Andy transitioned over to be the executive director, and I have spoken about kind of getting a better sense of conference property and what it is you guys have a holding of, is because it's very difficult to make use of something that you don't know is there. You also don't know what the limitations are. For example, if you've got a utility easement running straight through your property, you should probably know about that. So when I say, exceptions or things that are on property, those are basically things that are going to show up as recorded interest against your property. Some are unrecorded. That gets into the difference between line court and regular system and is a little bit far abreast for this seminar. But if you do have questions, I'm happy to answer it. But essentially, exceptions are things that are going to affect your title. So what I say here is that not all exceptions are created equally. This is a very generic exception that you're going to see on a lot of property out in West Oahu, West and Central Oahu. And there are all kinds of things like this. There are old water grants, there are Hiko utility easements, there are Hawaiian telecom utility easements, all kinds of things like this that you should know they exist, but they don't really affect your ability to use the property. On the other hand, there are going to be some other ones, like this guy, which is a use exception. I think I might have actually taken this from one of the deeds from Andy. I'm seeing him smile. I think that might be right, Andy. And the reason this is a little bit different is there are going to be some things that are recorded against your property that do limit the use. So if you can see the screen right here, this limits the use of the property only to church purposes. Now, what constitutes church purposes? That's also a separate discussion. But there are certain things that don't constitute church purposes. We don't have them here, but casinos, not a church purpose. Shopping malls, not a church purpose. So all of those things like that, because this exception is recorded against title, would cause, if you put a shopping center on it instead of using it for a church purpose, you potentially have to give the land back to whoever the grantor is. That's why it's important to have a good understanding of, hey, what do I have here and what's affecting it? So this is another very key broad brush point, but I really can't stress it enough. Get it in writing. I understand, especially, we do a lot of things on the handshake, the hug, the honey, like, oh yeah, my cousin, he's going to get this done for me. And that's great. I think we have a wonderful culture of it. For a lawyer, it's a nightmare. You can probably see how this goes bad, is that, Cousin Jack tells Auntie Lori that, oh yeah, okay, sure, we're going to do this. I'm going to sell you my car for X dollars, and we're all good. Time comes to sell the car. Oh, no, we didn't agree for that price. I want twice this much. Well, that's not what you said. So I cannot stress enough, please get it in writing. And people have said, what's the worst that can happen? We want to be good neighbors. We're a church, especially a lot of the churches and nonprofits I work with. And unfortunately, the worst that could happen is someone completely reneges on the deal, or they try to retrade the deal, or they back out and pretend you guys never met at all. Not everybody is as good as I'm assuming most of the audience is here today, but one way to get around that is please get it in writing. And that goes not just for your contracts, so your leases and licenses, that goes for side agreements you guys might have. And what I mean by that is, you've got your basic lease, you've got your basic license, but then something comes up where maybe they want to, I don't know, use portion of the outside space to show movies on Friday night. That's great. That's a really nice thing to do for a community. Send an email about it, get a confirmation back about, when they can use it, who can use it, who can be there. It just avoids a lot of the headache in the future. No, that's just to emphasize, no. From your lawyer, please don't do it. So you've heard me talk a couple of times now about a lease versus a license. And I think this trips up a lot of people because, frankly, it's not common knowledge. There's no reason why the average person walking down the street would know what the difference between a lease versus a license is. A lease, in simplest terms, is an interest in real property. You can think of that as a lease gives the lessee the ability to basically step into your shoes. They have full occupancy of the premises, 24/7. They are not restricted in what they're doing, their hours. Think of it like Macy's. They lease that spot at all Walk Center. They are always there. If you were to, for whatever reason, be at the mall at 1 o'clock in the morning, Macy's store is there. A license, on the other hand, grants you a right to do something or not to do something that you would otherwise see like for trespassing. It is not an interest in real property. The reason that we generally push licenses, especially for nonprofits, churches, and smaller entities, is that licenses are much, much more favorable to the owner. They are usually terminable at will. There's not a lot of notice processes involved. With a lease, you typically have to go through there's a whole notify them of the default, you've got 30 days, you need to fix this within 30 days. It strings on and on. There's also a whole bunch of, rigmarole associated with the lease in terms of maintenance and whatnot. But the license is almost always going to be appropriate. Unless the person is in that space 24 hours a day, 7 days a week, we would suggest a license. It's a temporary right to use the space. Think of this kind of like if you've got Group A that uses room 101 Monday, Wednesday, Friday, and Group B uses room 101 Tuesday, Thursday, Saturday, they would both have licenses. Neither of them would have a lease because they both have temporary rights to use that space. Andy, did you want to add anything here? I know that this comes up a lot with churches.
Yeah, it is it's a constant challenge for our churches to determine when a license is appropriate versus a lease is appropriate. And generally, you want to consider the nature of the use that's going on, the level of if the tenant needs to be there all the time, whether it's appropriate for the tenant to be maintaining and using the premises on a more exclusive basis. Generally, a lease would be a more appropriate option versus a license, where if they're just coming in, using it a few hours a day, something of that nature, that's you'd want to look at a license arrangement. The important thing to understand is a lease is an interest in real property. It attaches itself to the land versus a license. There's no land interest involved in a license. It's merely a contract right to use a property for a period of time, and tends to be easier to revoke if you need it. But it's important to have a real thorough discussion with your tenant about the nature of the use before you decide which way to go.
Thanks, Andy. The reason that Andy and I are kind of smiling at each other here is that we've had a lot of involved conversations about, which is appropriate. Well, we're just going to give them a lease. The answer is almost always no. We're going to give them a license. Well, what goes into an occupancy agreement? At the very, very bare minimum, I would recommend you put these things in. So your term and extension rights, your permitted use, your time and space availability, your maintenance obligations, which is kind of who takes care of the space, who's in charge of cleaning, do they need to restore it to the way it was at the end of every day? Are utilities included? This comes up all the time. People aren't always sure that, are they supposed to be paying electric? If they are, is it separately metered to the premises? If it's not separately metered, how do you decide how much to allocate towards them? Notice provision. That's basically, if you need to send notice, that's not just a bad kind of notice, like you need to notice to terminate, but it's also notice about a change in address, a change in hours, a change in what you, the fee owner, can do with your property. You need to notify your tenants. Most importantly, termination rate. You want to be able to know when you can kick somebody out. Nobody wants to get to that point, but it's much, much easier to do it when it's already laid out than it is when you're trying to draft things from thin air. So these are all the things that we suggest putting into an occupancy agreement. And the reason that I'm taking time to highlight this is that we've seen a lot of occupancy agreements across our desk. I put that in air quotes, I'm not sure. That are kind of, that one page and don't cover any of these things, and they just have someone's name and maybe some insurance requirements. And I understand that, people have a reasonable fear of long documents, and no one wants to get bogged down with a 60-page agreement when they're only going to be there for 2 months. But while I do generally agree that brevity is next to godliness, sometimes a little bit of length is a good thing, because it's better to know where everyone stands going into an agreement. It's much, much easier when things go south, or even if things don't go south. You just want to make sure the parties understand what's going on. So this is another item that comes up a lot: insurance versus indemnity. Number one question that I get from my church and nonprofit clients is that last question: well, our tenant doesn't have insurance, and they're relying on indemnity provision. The ultimate answer is going to be, you guys need to decide what's best for you. However, what I can give you in terms of guidance is that an indemnity provision allocates risk. It basically says, if there's a third party and something happens while you're on the premises, you have agreed, lessee, that you're going to step in and you're going to defend against us, or defend for us. An insurance policy transfers the risk to your third party insurer in exchange for, you get the premium. So in terms of, can I rely on the indemnity provisions of the insurance? As a lawyer, my gut reaction is almost always no, because they cover different things, right? They serve different purposes. I do understand that we are going to come into situations where either smaller tenants, or sometimes they're individuals. They're not going to have a big old giant general liability policy. And at that point, I think that you would want to talk to your individual churches and your boards and figure out, what is our policy going forward for these kinds of things. So who owns the improvements? This is another one that comes with a fair amount. Really easy. Like if they are licensing, using a room in a center, well, basically, or over the space, they own the improvements. Those are your walls, your desks, your whiteboards. There's no question about that. Where things get a little bit tricky is where a tenant or a licensee constructs something. So think of a playground. Let's say that as part of their agreement, they need to be able to, they want to build a playground. Now, most leases and licenses, if it's in there, it's part of the quality of lease, they want to either, when you surrender the property, all improvements revert to the owner, or when you surrender the property, you need to make it, bring it back to the way it was. So, as to the question as who owns the improvements, it really depends on what your lease says. But that's why it's important to address this at the outset. You want to make sure that you know and your tenant knows what their expectations are. You'd avoid the whole mess later on when they're saying, well, this has value and we should take it, and you're saying, no, it's part of the premises now. You surrendered it. And the lease, you gotta go. And that goes to part of the second question, which is, should I stay or should I go? And rights the improvement after expiration or termination of the agreement. It's really, really much easier if you just include it up front. This is unfortunately one of those terms that I think a lot of people that are kind of drafting on the fly or drafting off the internet form tend to miss. Because a lot of people think about the terms that they're going to do up front, like the rent amount, or the term of the lease, or the expiration date, those kind of things. Very few people think about, okay, what's going to happen after this? Oh, this is a little bit less relevant for you guys. I've done this presentation for a few different churches. As I understand it, and Andy, you can correct me if I'm wrong, your churches are almost all separately incorporated and own the interest in their property. Is that correct? Yes. Okay.
That's correct. Most of our churches are separately incorporated. That's correct.
Okay. In which case, it's not really a question. You're the fee owner. You sign as the licensor, or you sign as the lessor. Where it gets a little bit weird is I guess if you're saying most, there must be some churches that are not separately incorporated. In which case,
there's also churches who, even though they are separately incorporated, the lands are owned in trust by the foundation for the benefit of the church. So you have, though the church is the user of the property and is signing leases and is doing things with the property, the foundation owns the land and occasionally would need to be involved in decisions such as mortgaging the property or signing a major construction contract, applying for building permits and that sort of thing, which is what we do for those churches under those circumstances.
Perfect. That kind of takes care of the color that's specific to your church. And my only point to add to that then is, just make sure that you do go up the chain of command and do make sure that when you need to get them involved early. We represent a lot of landowners, and there's nothing more jarring to somebody that comes back to us, 6 months down the line. You're like, oh, you need this done by next week. Great. Can't wait. Real property taxes is another one that comes up a fair amount. So there are a number of exemptions. There's a section right there. You can take a look. Just Google revised ordinances Honolulu, section 8, article 10, and the whole thing will pop up. The most common for churches are going to be your charitable purposes and for-profit group child care centers, at least in my experience. And basically what you need to know is that in order to qualify and keep your exemption, you need to be engaging in use that qualifies for an exemption. So what that means is, let's say that you, a church, you may be exempt from real property tax. And if you were sitting there and doing nothing else other than church services or community functions, anything related to church services, you'd be in the clear. Real property tax exempt, you're good to go. Where things start to get a little bit hairy is when you start letting other people use your space that don't qualify for exemption. For example, let's say that you've got multiple rooms in a center that's owned by the church or a church itself. And your friendly neighborhood CPA says, hey, can I use a room in here for once a week during tax season? And once you get a good neighbor, you say yes. And that's great. The thing is that for the period of time and that space that CPA, who is presumably a regular old for-profit corporation or company, is using that space, the real property tax exemption is no longer available. Now, it sounds complicated, and to some extent it kind of is. But what you would need to do in that case is you would need to work with real property tax office and give them what we call plat map, which is basically a fancy way of saying a map of premises. You kind of cross-hatch for them the area that person is using or entity is using, and the real property tax office will work with you to figure out how much of that tax exemption goes away. That being said, it is traditional to pass on any tax obligations, real property, GST, to your tenant. So this goes towards Annie's point about making sure your tenant knows what they're getting into at the beginning. Your agreement should always provide that the tenant's going to be responsible for any taxes that might be assessed to property. And so while you, the fee owner, might have to actually work with the public tax office, you can pass that obligation on. And obviously, where people get into trouble with this is that they don't necessarily think of another person using their space once a week as jeopardizing their real property tax exemption, but it does. And it doesn't only jeopardize it for that site, it will jeopardize it for any and all other holdings that entity has. So this is a big one. Also related is general excise tax, because this comes up often. A lot of people say, oh, well, it's a church, so we don't need to pay GET on our leasing and licensing transactions. And that isn't true. GET, so while a lot of churches and nonprofits are exempt from state and federal things like income tax, real property tax for the state, for the county, general excise tax is actually charged on the business, not to the customer. So, I would say 99.9% of the time, a transaction is going to have general excise tax attached to it. We almost always recommend wrapping it into your fee, and that's why you're going to see arrangements like when we send out engagement letters to our clients, we say any fees are going to include general excise tax. Or when you buy something, you say, X dollars plus GET. And that's because that business is taking on the obligation that they have to pay general excise tax to the state. Nothing certain in life except death and taxes. And they're passing it on to you. So basically it works as what we call a pass-through taxation for them. And while there are exemptions, you can take a look, and again, if you want to, you can Google Lawyer by Statute, Section 237-24. GET is a lot like real property tax, exceptions that can swallow the rule. I think one of the weirder cases that I didn't deal with, that I heard about or came across from someone else, is that there was sort of a trade fair set up, and I think it was a nonprofit that had some kind of booth at trade fair. But the nonprofit is normally exempt, so normally benefits from GET tax. But when they sell anything at their booth to someone else, state comes in and says you got to pay GET on top of that. So a good way to think about this is you're almost always going to be paying GET. It's just the way we run. I think GET might actually be the first or second biggest revenue driver in the state. So, you're going to get theirs. This is a part of letting other people use your property that no one wants to talk about. Your tenant's in default. It happens. It happens if maybe they are late with the rent, or they didn't build something they were supposed to build. There's a million ways that it can happen, but you should provide for it ahead of time. Again, so there are really two options. Like the screen says, you can play hardball, or you can work it out. Also, like the screen says, there's really no one-size-fits-all approach. My almost always go-to is, unless someone is being completely unreasonable, taking the premises unsafe, acting in a way that's against the values of the owner, or any of those things, working it out is almost always the better option. There's a couple of reasons for that. One, it just preserves, that. And you can get to the point where you're only talking to each other for attorneys, but no one wants to get there. It's not fun. It's not even that fun to lawyer, to be honest. The other reason that I would almost always recommend working it out is that something of part of the rent is better than all of nothing. And we've seen it come up a lot, as you guys can probably imagine, during COVID. As businesses slow down, they have to figure out what they can do. And the more reasonable property owners, I think, my estimation, and you can correct me if you want, are the ones that are willing to do kind of workout agreements and take X amount of dollars as they go along. Of course, there are going to be situations where really the only reasonable thing to do is say, I'm sorry. Here's a 30-day notice of termination. Get out of the property and keep it vacant. The other thing that's related to this is please call your attorneys early and call your attorneys often. I know that when people hear attorneys, they think legal bills. I get that. But one of the easiest ways to avoid a giant legal bill is to get us involved ahead of the game. That way we can at least get a chance of what's going on. We can figure out a good game plan for you guys going forward. There is nothing more expensive than trying to do cleanup on a rush schedule. That will always, always, always result in a larger bill. And frankly, if you get this involved early, we can probably walk you through some rights, remedies that you weren't aware you had. So it's just a good idea. So, conclusion, we wrapped up a lot earlier. We did last time, I think it's the nature of Zoom presentation. But what you own, what you can do with it, and what you're willing to let third parties do with the property. If there is a use restriction on your property, be careful. If you aren't sure about this tenant, be careful. Always look them up on TCPA. Make sure that they're a real corporation. Being a good neighbor is good. That's wonderful, and I think that a lot of churches and nonprofits exemplify that. But knowing how to get rid of a bad one is even better. Which goes back to my point about know how to terminate your contract. Make sure that is included at the outset, and make sure you know how to do it. If you don't know how to do it, call us. And the last point, and this is only because it's been at the forefront of my mind a lot lately, is know when you're on the hook for taxes, no property tax, no excise tax, income tax, although I can't think of properties in market. And if you are, make sure they get paid. If it's a question of, my lessee is supposed to be paying this and they're not paying it, pay it, and then bill the lessee. It's just much, much easier. One of the only things that's harder than trying to work things out between two attorneys is trying to work things out with them or state government. So be proactive, get in front of things to the extent you can. And I think at this point, unless Andy wants to add anything, I'm happy to take questions.
Thank you, Kimi. That was terrific. A lot of very important points. I think shining a little light on your discussion of the workouts when you have a tenant in default. We're in a period of time right now where tenants are challenged by the current economy, particularly those who are in the restaurant and tourist industry. They have no source of revenue, so they are having a challenge paying their rents. And in that environment, we're discovering that it's good to try and do workouts, and we've had several incidences come up where we've sought to structure a deal where we try and defer the rent until a better time. So hopefully if the economy recovers and the tenant recovers, everybody participates in the end of the day. But where you don't have somebody lined up for the space, it's not a space in demand, it's better to, in these tough times, to try and keep the tenant for when the economy recovers so that you do have somebody there. But every circumstance is going to be different in that regard.
Right. So how does Q&A work? How do you guys want to do this, Laurie?
Let's see, Laurie, do we have any questions?
Yes, we do, and I'm going to defer to Dorothy or Julie or Lorraine.
Okay, so we have a question from Michael, who is asking if Kimi, if you could address COVID compliance terms in leases.
Sure, I can speak to it generally, with the caveat that, like everyone else with COVID, we are learning as we are going. And a lot of our experience with COVID so far has been, as Andy's alluded to, like trying to figure out workouts, and we're already in this space. But I think what you're getting at, and you can supplement your question if you're wrong, is you're talking about going forward. So you want to enter into a new lease with somebody or a new license with somebody during COVID. And off the cuff, a lot of the same provisions are going to apply. You're going to have the same entry rights, termination rights, all of those things. But I do think that it would be worthwhile to put something in there about, one, acknowledging COVID is there. Two, understanding that if you are required to shut down or just requested to shut down by the owner, that they need to abide by that. Because, you know, I think we're now, tier 1, tier 2, tier 3, all of those different businesses. But as a private landowner, you have the right to do what you want with the property. If you don't think it's safe to open, you can tell your tenant, look, sorry, you gotta close down. So that's something that's important to put in there. I think it's also important to make sure that you know who's in charge of sanitizing the space. That's another big one that's been coming up. I have some friends who have some clients that are big cleaning companies, and he said that they have been just insane. So, you know, make provisions for that. Also make provisions for if you do need to terminate the agreement because of COVID. What happens if people have prepaid rent? It shouldn't be more than a month in advance anyway. You know, they should just get pulled out of what. Has that answered the question, or is there something specific you guys are looking for?
I mean, I'll riff on that a little bit. You know, I think your initial point is good, and it is the key to remember is that a well-documented lease or operating or you know use agreement should, even under the pre-COVID times, its terms should generally cover COVID concerns in that it should address provisions requiring compliance with law, so that if it is the tenant's duty to make sure they meet legal requirements in restricting use of the property or cleaning the property, that it is bound to do that under the lease, that it has very clear provisions relating to the use of the property and the obligations relating to maintenance. If it's a use agreement where somebody's just coming in a few days a week to use the parish hall or something like that, then clearly the church is going to have to assume the duty of cleaning that facility and making sure it's safe for the tenant. And under that analysis, the church may not choose or may not want to rent the facility until times are better. Whereas if it's a complete lease of the space where the tenant has 100% control of the space and the duty to maintain and clean it, then you know that those obligations have been transferred to the tenant, and it needs to you know abide by that. And it should have good insurance provisions to the extent there's a liability claim against the landlord, the church who's renting the property to somebody. You want to make sure that you have some coverage available under your both the church's insurance and that the tenant is carrying insurance of some sort. Some tenants have you know argued that their lease has a provision that says, hey, this is an event of force majeure, it's something we didn't think of, and therefore I'm excused from all my obligations because who knew a pandemic would take place? The reality is that most leases, the force majeure clause in a lease, that's a clause that excuses you from unforeseen events, excuses performance issues. It would excuse an inn operator from having to generate, you know, to operate the inn. It would excuse the restaurant tenant from having to operate the restaurant, but they generally do not excuse the tenant from paying rent. So that's something that most tenants and landlords, they often get fumbled on that provision. That's aside from the question of whether or not they actually can pay rent because of the economic situation. But anyway, having a well-documented lease that addresses those issues is what you need in when you're considering these COVID issues.
Yeah, and actually to Andy's point about that, you know, we have seen a lot of people raise things for the force majeure provision, or kind of another way that we use the act of God provision or unexpected event. And one, like Andy says, it almost never gets you out of payment. In fact, most force majeure provisions, if they're any good, have a sentence at the very bottom that says, notwithstanding anything in this first paragraph, you need to pay rent. Second of all, from the analysis that's coming out now, and again, being generated as we go. At this point, the pandemic is no longer a unforeseen circumstance. Could have probably rolled on that maybe March, April, but it's now, God, it's now up. So, we've been in COVID, we're going to be in COVID, so it's something you need to plan for. It's not something that people can take, well, I had no idea. I didn't know that there might be government regulations coming. I didn't know that I might close on short notice. I hope that answers the question, but again, let me know.
Okay, so we have a question. I'm not sure if this is the exact question. If it's not, Charles can resubmit it. I think he's asking, how do you find out how a property is held, such as how do I find out if a property or land is held in trust by the foundation?
Well, the easiest way, I'll jump in right at the top and say you can ask the foundation if you're, if your church. We know what institutions we hold properties for, and so I would invite you to send me an email or give me a call, and I can tell you whether or not the foundation holds title to your property, and that's. It's an important thing to know, especially if you're a church leader. I definitely want to have a discussion with you and establish the relationship. So I do invite you to contact me about that. You can also, if you're too shy to talk to me at the foundation, and please don't be, but if for whatever reason you wanted to investigate on your own, you could go to the Bureau of Conveyances, and they have all the title records to properties in Hawaii. And as Kimi pointed out in the beginning of her presentation, you could have a title company do a title search for you. And I would say that if your property has never been searched, it's probably not a bad idea to have a title company do a search, so that one, you can confirm the actual that the church is indeed the title holder of the property, and two, it's good to know if there are perhaps any claims against the property or easements or other what we would call encumbrances against the property that you would need to be sensitive to or deal with.
And also to that point, if it's for a property that's not related to the foundation, just generally, you can look it up on the Hawaii Real Property Tax website. You'll be able to Google it via, you'll be able to search it via address or tax number, and it'll show who the registered fee owner is.
We have a question. About if you have a license that you are planning to terminate, is it typically done in the court process?
No.
Termination of a license. Do you go to court?
No. So, well, let me say this again. Ideally, no. One of the best things about a license is that they are really revocable, which means that they're pretty much terminable at the will of the license. Normally we put things in there with X amount of days notice, but if it's not in there, then they're pretty much revocable at the will. The only reason that you would go to court is if they are refusing to leave, if they are refusing to pay damages, pretty much if they're acting outside the scope of what you guys are doing. But a normal termination, no, you do not need to go to court for it. Again, that's the beauty of a license. Even with a lease, you shouldn't be having to go to court. You should be able to follow the provisions, like Candy says, like I said, that are clearly laid out, hopefully, in your use and occupancy agreement, whether it be a lease, license, a one-time use agreement. There should be something in there that says, if so-and-so does this, this is what we need to do to get them out.
Okay, question from Gordon. He is asking Kimi if you could please go over real estate taxes again, especially day use of a church hall.
Sure, happy to. This one does trip a lot of people up. So, as a church and church purposes, you are exempt from real property tax. One of those nice things that's been built into our statutes and our ordinances, and that churches do good things for the community. We want to encourage that. Also, on the whole, churches don't make a lot of money. And so the money that they do have, I don't think really should be going to make the property tax, that kind of thing. However, if you let somebody use your space that would normally have to pay a tax, so the example I used was an accountant, but it could be pretty much, it could be anybody. It could be a group care facility. It could be a parking arrangement where a parking company says, hey, can we use your 20 stalls up front and we're gonna let people come in and park for $4. That's $4 an hour and you guys get 2 of those. Any of those things. So anytime that you let someone use your space that would not otherwise be tax exempt, real property tax exempt, that portion of your property that that user is using no longer gets the benefit of real property tax exemption. What you would need to do is you would need to take a kind of a picture of your whole property, a site map, if you will, mark the area that's being used, and contact the real property tax office. I've worked with them on a couple of these. They're actually pretty helpful and pretty nice about this, especially if you're coming to them ahead of time, because they understand that you're not trying to shy away from paying the tax. You're just trying to figure out, what is the percentage that I owe. So if you think of your property as like a giant rectangle split into, 8 different rooms. Let's say there's 8 different rooms in your church, and the parish hall is one of the rooms. And you let somebody use the parish hall who would not normally be tax exempt. That portion of the property needs to pay real property tax. So it's basically allocated on a pro rata basis relative to the property. Let me know if that was.
And a question. Oh, are you? All right. A question from Linda regarding who signs a lease. Can any officer of the Board of Trustees do that? Sign a lease?
It depends on what your documents say as to who can bind. I'm going to look at Andy for this one. It's different for every entity. It's different for every corporation.
Yeah, correctly. That's going to be a question that your bylaws should address. If they don't, they need to address it as to who has authority to sign on contracts on behalf of the church entity. And typically it would be 2 officers of the church corporation who would sign. It will depend from church to church as to how you're set up, but it would be my recommendation that, if you don't know, that you clarify that and get some guidance on some bylaws provisions that will provide that level of authority. Absent that authority, the Board of Trustees, the Board of Directors of the church could appoint any person to act as an agent for signing documents where they've specifically authorized that. But you need to make sure your bylaws address the default condition as to who has authority in absence of a specific resolution of the Board of Trustees.
Question from Russell. If the property is owned by the conference with the use language for the church, can the church /license agreement by the conference attorneys, or do we have to pay for outside counsel?
This is an Andy question. This is an administration question.
Well, as part of our covenant with our churches, the churches would absorb all the operating expenses related to using the property. So if the church decides to lease or rent the property and desires to hire an attorney, we typically, the church would do that, and that would be at the church's expense. We can, I can talk with folks generally about process and about issues, but absent, unless the church absolutely does not have the means to pay for any of these types of expenses, in which case we can talk about how we work that out. The expectation is the church would pay for those expenses, and I would recommend that the church seek counsel with respect to important contracts of that nature.
Do we have more questions?
I'll fill the void for a second here, Dorothy, and say that for as most folks know, I'm new to the foundation, but we have the foundation does have with some churches use agreements, just to clarify those questions that have come up about when does the foundation pay for something, when does the church pay for something. And it's also helpful for the church to have that. So when they're turning around and leasing the property to somebody else, or using the property, or calling the police because there's a trespasser on the property, they can show that they have there is a use agreement. They, in fact, as an organization, have the right to be there. It is my hope eventually to get all of our churches who we have a relationship within the foundation on use agreement, so we can clarify those expectations so there's not confusion going forward. Unfortunately, many of our churches we don't have use agreements for, and that's just an accident of history, but it's something that in terms of trying to clean up things and clarify relationships that I hope we can get to in due course over time.
Well, if we don't have any more questions.
One more question from Charles.
Okay.
How about insurance purposes, the policy? Sorry, could we get a copy or general information about insurance? Is what I think is being asked.
So I think what you're asking me is what insurance requirements are. Again, this is gonna vary depending on your organization. We do have a recommended set, but I'm willing to bet that the foundation probably has a list of recommended or suggested coverages for each church that they expect them to be carrying. Andy, is that right?
Yes, I mean we every church should be carrying a policy of property insurance, which covers the physical improvements in the event of a fire or other types of casualties that cause the destruction of the buildings on the property. It should also have a commercial general liability insurance policy, and that is a policy that protects the church in the event of personal injury claims, slip and fall type claims, those types of situations where a third party gets injured on the property and wants to hold the church liable for those injuries. A church should also have directors and officers insurance policy. That is a policy that covers your church board from claims of malfeasance or misdirection or improper conduct. The church board are all volunteers and they do the best they can, and it's important to make sure they have some insurance protection in the event there's a claim. If you have employees, you should have an employment practices policy, and you should have workers' compensation insurance policy in place. And that's a lot of information that I'm just pumping out, and we can provide you with sort of a written explanation if you contact me of the types of insurance you should carry. And I would also highly recommend that you reach out to the insurance board, that is the United Church Insurance Association. The conference ministers of the United Church of Christ are actually the members and owners of an insurance company whose sole purpose is to provide insurance for churches, and the insurance board does a great job doing that. I think by and large most of our churches have insurance board coverage. And there's a website which has some terrific resources that you can access about insurance and what you need and what you should have as a church organization.
We see no more questions.
There's
Wait, I
one
see
more.
one more question, I think. I think it's, do most churches have coverage through the conference? No. Most of the churches, many churches that have, whose property the foundation holds in trust are covered by a blanket insurance policy that the foundation obtains for those churches. But there are many other churches that don't have a relationship with the foundation or who have the wherewithal to carry their own insurance policies. And in those cases, the churches should have their own insurance policies. And the Hawaii Conference itself does not provide insurance for any of our churches that I know of.
Our time pretty much has come to an end this evening. So thank you, Kimi, so much for being with us and sharing your insights and guidance regarding church property. We are all now going to go and look at our bylaws and our insurance policies and all the leases and licenses that we have or do not have. But we will be posting Kimi's contact information, if that's okay with you, Kimi,
That's
on
fine.
our website.
That's fine.
Okay,
Thank you guys
great.
for watching me. I really appreciate it.